We're going to share some words. Anne Marie Yeats from the New York State Office of Temporary and Disability Assistance, Division of Child Support Services, Bureau of Policy and Training, will be sharing a couple words, and then after that, her presentation is going to be very fun. It's going to be interactive.
Good morning. Thank you very much, Mel. So I'm hopeful that this presentation is going to provide you with a lot of valuable information. I encourage you to jot down any questions that you might have because we will have a Q&A session at the end of my presentation. The LDSS 5171 Acknowledgement of Parentage is a form that parents can use to voluntarily establish legal parentage for a child without having to go to court. An AOP that is voluntarily signed by both parents at the local birth registrar has the same legal force and effect as a court order determining the child's legal parents and establishes the duty of both parents to provide support for the child. This means that if the AOP is not challenged, parents do not have to go to court or an administrative proceeding to determine or confirm the child's parentage. Before passage of the Child Parent Security Act in 2020 and its implementation in 2021, gestational surrogacy was illegal in New York State. New York law also posed significant challenges for some parents in establishing legal parental rights with their children. In particular, establishing parental rights was difficult for same-sex families and for families that were formed utilizing assisted reproductive technology. Assisted reproductive technology is the application of laboratory or clinical technology to gametes and/or embryos for the purposes of reproduction. LGBTQIA couples had to endure an invasive, expensive, and time-consuming process, often including home studies and court-ordered adoptions, to ensure that both parents and children were protected by a legal relationship. The Child Parent Security Act expanded protections for LGBTQIA families in New York State and streamlined the process of creating binding legal relationships between children born through assisted reproductive technology and their parents. The Child Parent Security Act modernized New York law by adopting best practice recommendations of the American Bar Association and the New York State Department of Health Task Force on Life and the Law. This law ensures that intended parents who enlist the help of a third party to conceive their child have a secure legal relationship with their child from the moment of birth. It legalized gestational surrogacy, where the surrogate's egg is not used and the surrogate has no genetic connection to the child, provided that the arrangement follows best practices in the field that protect the interests of surrogates, intended parents, and the children. This is not a situation that would be addressed with the signing of an AOP, but it's a change in New York law that you should be aware of. The CPSA eliminated demeaning and expensive requirements for securing legally enforceable parenthood for same-sex couples and others. For example, the partner of a person giving birth can now be named as the legal parent of their newborn child immediately after birth, whether or not they are married, creating a legally binding parent-child relationship as soon as the child is born. And the CPSA ended uncertainty for securing legal parenthood for single women who rely on a sperm donor to build a family. Again, I know we've reviewed some of these, but I'm going to just go through them again very quickly. Some of the benefits of establishing parentage include having a legal record of the identity of both parents. Both parents' names will appear on the birth certificate. The family will have better access to information on family medical history. The child will have the emotional benefit of knowing both parents. The child will have a better likelihood of getting financial support from both parents, including child support, Social Security benefits, veterans benefits, military allowances, and they may have access to health or life insurance. It establishes the child's right to inherit from the other parent. The parents can share child-related responsibilities. And the other parent will have their parental rights legally established, including the right to seek court-ordered custody or visitation, and the right to be informed and to have a say in adoption proceedings. Public Health Law Section 4135B1A tells hospitals that they need to provide the AOP form and information to parents and then file completed forms with the local birth registrar. I'm not going to go through all of this information, but you will have these slides if you want to read these later on. Public Health Law Section 4135B1F details what information must be provided. This information provided mirrors pages 1 through 4 of the AOP form and the contents of the video titled Acknowledgement of Parentage in New York, which was shown earlier in the conference. Before signing the AOP, each parent must understand what they are signing. By signing, both parents are indicating that they understand this is a voluntary process, that it has the same force and effect as a court order, that they have received oral and written notice of their rights and responsibilities, and that the information they are providing is true. The birth parent is indicating that the other parent is the only possible genetic parent or the intended parent of the child. And the other parent is indicating that they are the genetic or intended parent of the child. If any of these statements are not true, but the parents choose to submit the form anyway, it will be up to the court to determine if the AOP was void at the time of signing. These are images of posters, and these QR codes link to the two videos that are available. The first is that Acknowledgement of Parentage in New York video that you saw earlier. And this video, as you saw, explains when parentage needs to be acknowledged, what signing a voluntary AOP form means, and who should or should not sign this form. This video meets the legal requirement for oral notice, so it can be a useful tool for hospitals. You can print these posters and hang them in your labor and delivery rooms so that parents can readily access the videos. They can also be accessed from the Division of Child Support Services website, or you can email the parentage mailbox to request DVD copies. Again, these are one of the posters is for the videos in English, and the other shows the videos with Spanish subtitles. The second video that's shown on there is completing the acknowledgement of parentage form. And this explains how to complete and file the form. And it can help parents to avoid errors that could cause the form to be delayed or rejected. This is a valuable resource for parents who opt not to sign in the hospital, but may wish to do so later. We certainly encourage everyone to sign in the hospital if they're comfortable doing so, but this is a resource that's available. So now we're going to do a quick activity called Find the Errors. I'm going to show you a completed AOP in 3 sections and give you a moment to review each section. Please review each section and indicate the number of errors that you see in the chat, and then we'll go over them all together afterward. So this is the child section. How many errors do you see in this section? Please look it over, count them up, and then type your number into the chat. Okay, I'm seeing some 3s and a 4. 3s and 4s mostly. Wait, there's 4. I see a 5, a 6. Okay. All right, let's move to the next section. How many errors do you see in this birth parent section? Again, please put your number in the chat. Okay, some 3s, 4s, 3s, a 2, 4, 3, 3, 2. Two, 3, and 4. Apparently, my dog wanted to say hello. Okay, and now let's move to the last section. This is the other parent section. And how many errors do you see here? Okay, we have 3, 3, 4, 4. 3, a 5 in there. See a lot of 3s and 4s, a couple 5s. A 6, okay. Some more 4s and 3s. Okay, great, thank you. All right, let's go over these together then. So the first error is right up at the top. In the check where signed section, there's no option checked. And that's so if you're looking one of these over and that's not checked, you should make sure that it is checked before submitting. The next is that there's a crossout in the child's name. The reason why this is a crucial error is because there are times when parents are not signing at the same time. I know this probably doesn't happen very much in hospitals, but outside of hospitals, there may be AOPs that are completed by one parent and then mailed to the other parent. This is if they live in different states, if they live in different countries, there may be one parent in the military. That for a variety of reasons, they may be completed via mail. So if there's a crossout, then there's no way to ensure that the parents agree on the name. Even in the hospital, let's say if the birth parent could be sleeping when the other parent signs, a change could be made without the birth parent's knowledge or consent. So this is why crossouts in the child's name will cause the form to be rejected. There is no city or county of birth. The birth parent date of birth is not legible. It's difficult to tell if it's 2000 or 2001. The witness signature dates do not match the parent signature dates. What this indicates is that the witnesses could not actually have watched the parent sign if they're signing on different dates. If these are merely errors, then they should be corrected by the parent or the witnesses before signing. I know that when I gave birth to my children, I was fuzzy. So I could easily see how a parent could write an incorrect date, or anyone really could. It's a simple mistake to make, but it's also a simple mistake to correct. It can be corrected with a crossout and initials. Now, the missing Social Security number is not an error. The Social Security number is not a required field. Not everyone has a Social Security number, and those who do not can't be prohibited from completing the AOP form. The other parent name is not legible, and the other parent checkbox is not checked. So those are all the errors that appear. So again, these errors are errors that can be corrected if they're pointed out and identified before the form is submitted. This is an image of a desk aid that we created to help hospitals and registrars. So what it's indicating is that if you go through this checklist, you would make sure that all dates of birth are complete, correct, and legible, that all names are complete and legible, that the child's name is free of crossouts or corrections, the child's birthplace is complete, both parents sign the form, and birth and other parent checkboxes are checked. Certainly, there are other things that we want to ensure, but these are the primary things that if you check, you are likely to prevent the form from being rejected. When an AOP is not legible and complete, it can cause hospitals and local registrars a great deal of extra work to have to reach out to parents, often multiple times, to get the forms corrected and returned. So we're hoping that if you use this desk aid, you can reduce the number of AOPs that get rejected. And again, a copy of this, a PDF of this, will be included with your materials after the conference. This is another resource. This is a decision tree, and it's a tool that you can use to determine whether a family should sign an AOP. So we're going to actually do a quick activity. In this activity, we're going to walk through some scenarios to familiarize you with how the decision tree is used. I'm going to read each scenario, and then Izzy is going to launch a poll to collect responses. Then we'll show the results and review the scenarios together. Scenario 1, Pete and Sally are both unmarried. Sally has given birth to a baby, and both Sally and Pete believe that Pete is the other parent. Can Pete and Sally sign an AOP? Okay, so we see 97% of people said yes, they could sign, and 3% said no. So let's take a look at how we would use the decision tree to figure this one out. Pete and Sally are both unmarried. So where it says, is the birth parent married? The answer would be no. Sally has given birth to a baby, and both Sally and Pete believe that Pete is the other parent. So we go to other parent is the alleged parent of a child conceived naturally. So yes, they can sign an AOP. So let's go to scenario 2. Julia has given birth to a baby. She and Carlos both believe that Carlos is the other parent. Carlos and Julia are not married to each other. Julia is married to Juan, but they are legally separated and they have been estranged for over 5 years. Can Julia and Carlos sign an AOP? Okay, so it looks like 85% said no, that they could not, and 15% said yes, they could. So let's, again, back to the decision tree. Let's have a look. So Julia is married. So from where it says, is the birth parent married? We go to yes. However, Carlos is not, the other parent is not the spouse. Carlos is not her spouse. So no, they cannot sign an AOP. Let's move to scenario 3. Santasha and Darius are both unmarried. They could not conceive a child on their own, so they conceived one together using in vitro fertilization, and Santasha gave birth to a child. They want to establish parentage. Can Santasha and Darius sign an AOP? Okay, so we have 97% said yes, and 3% said no. So let's go through this one together. Santasha and Darius are not married. So when the question is the birth parent married, you would go to no. And Darius, the other parent, is the intended parent of a child conceived using assisted reproduction. So yes, they can sign the AOP. All right, let's go to scenario 4. Emily and Sarah are married to each other. Sarah carried a child conceived from one of Emily's eggs and sperm from a donor. They want to establish parentage. Can Emily and Sarah sign an AOP? And do Emily and Sarah need to sign an AOP? So now there's an extra question to answer. Okay, so for the question, can Emily and Sarah sign an AOP? 79% said yes, and 21% said no. And do Emily and Sarah need to sign an AOP? 25% said yes, and 75% said no. Interesting. So let's go through this one together. So Emily and Sarah are married, so that we go to yes, and the other parent is the intended parent of a child conceived using assisted reproduction. So yes, they can sign an AOP. In New York State, if a couple is married, regardless of gender, the spouse of the birth parent is the legal other parent of the child. So an AOP is not needed to establish parentage. Currently, the Supreme Court decision Obergefell v. Hodges provides same-sex couples the right to marry. However, we've seen Supreme Court decisions reversed in the past. Same-sex parents may sign an AOP to add an extra level of protection. The AOP has the same force and effect as a court finding of parentage and is entitled to full faith and credit in other states. So if that decision were to be overturned, parentage would not be impacted. And finally, we go to scenario 5. Amaya and Tennille are married. Amaya was unable to carry a child. A child was conceived using one of Tennille's eggs and sperm from a donor. The baby was carried and delivered by a surrogate. Can Amaya and Tennille sign an AOP? Okay, so we have 65% said yes and 35% said no. So this is our final one that we'll go through together. In this case, neither Amaya or Tennille are the birth parent, so they cannot sign. In order to sign, one parent has to be the birth parent. And in the case of a surrogate, that's not the case. So again, as I mentioned earlier, surrogacy is not a situation that can be established using an AOP. In New York, legal parentage for children born via gestational surrogacy is established through the Child Parent Security Act, which requires a comprehensive surrogacy agreement signed by the intended parents and the gestational surrogate before medical procedures begin, and the issuance of a court-ordered pre-birth order that declares the intended parents as the legal parents from birth. Both parents must have independent legal counsel, and the agreement must meet specific legal requirements to ensure enforceability and protect all parties' rights. So again, if you're dealing with a surrogacy situation, there's no need to offer an AOP because they would not be able to sign. So this decision tree will answer most questions that you may have regarding whether a couple can sign. There may be scenarios that require additional research, but most will not. And again, you'll receive a PDF of this decision tree with your materials that you get after the conference.
I know folks had a lot of questions and it was very interactive in the chat. So as for me, I'm happy to. I don't know what others think. It's all good.
Yes, I'm certainly happy to either address questions or if anyone has specific scenarios that you would like to see how that would work with the decision tree, you can either raise your hand and they can unmute your mic and you can go ahead and speak your scenario, or if you'd prefer to type it in the chat, that's fine too, and somebody can read those off to me. Because Emily and Sarah are married and the other parent is the intended parent of the child, they can sign an AOP even if they're married. When there's an assisted reproduction, that's the only time married folks should be signing an AOP. Again, they don't need to sign an AOP because of the presumption of legitimacy in New York State. A child born to married parents is presumed to be the legal child of those two parents. So they don't have to sign an AOP in order for both those parents to be on the birth certificate. And it's always been that way. However, in the case of having a same-sex marriage and using assisted reproduction, they can sign an AOP because that can provide them with an additional protection, an additional way to establish legal parentage. Again, as I said, currently, same-sex marriage is legal in all states in the country. And that's based on a Supreme Court decision. But if that decision is ever reversed and the protections provided by a legal marital union are no longer in place, the AOP would be the backup to establish that legal parentage, because the AOP has the same force and effect as a court finding of parentage, and it is entitled to full faith and credit in other states. Does that clarify for whoever had asked that question?
They said got it in the chat. How would we know if there was surrogacy involved?
Typically, I mean, you're going to know if the birth, I mean, I'm guessing they would probably tell you, because I'm assuming that the birth parent is recognizing that. I mean, I think that with a birth parent is a surrogate, aren't they identified, but then that's sealed or something, and then the parentage is granted to the two intended parents? I'm not sure how that, I mean, I don't know the vital records process for that. Maybe somebody from vital records can speak to that. But I would guess that you would know. I mean, typically, I think that if they're surrogates, the surrogate parent, the birth parent, is probably going to be accompanied by the parents who are going to have the child.
Good morning, everyone. My name is Evelyn Rosa. I'm one of the managers for patient access at Mary Presbyterian Weill Cornell. I manage the birth certificate area here. In reference to the question of surrogacy, the way we manage it here is that we are informed by the doctor's office anytime we're getting a surrogate. So we have a team of care management, birth certificate, patient services, the clinical team. We all meet, review, because everything gets reviewed, all the paperwork and documentation, the birth plan. We speak to the intended parents, get their information, tell them the process, like the birth certificate worksheet is going to be completed by the birth parent, but it will only have her information, because then they are instructed, the intended parents are instructed to go to the Department of Health with their order of parentage to get the correct birth certificate with their information under the baby. That's the process we do here at Cornell and all our other sites. So we do know in advance, so we have that clear communication with both intended parents as well as the surrogate and their OB physician. That's how we know when we get a surrogate case.
Thank you, Evelyn. That's very helpful. And this might be something worth discussing further in the discussion portion of the conference to find out if some other hospitals want to indicate how they would know. I personally can't speak to hospital practice, so I can't really answer that question for you, but I think it would be a good discussion point.
Another one, I think you should be able to answer it pretty quickly. It says here, how do we know if birth parent is married? Sometimes they don't tell us, even if we ask in the event of an AOP.
In that situation, you wouldn't really have any way to know. If they don't tell you, if they're not truthful about that and an AOP is completed, then that can end up being void if it ends up in court. If, for example, the spouse wants to dispute parentage in court, then that would likely be overturned. But you have to just go on the information that's presented to you. Okay, so this brochure is titled Establishing Parentage. It's available in English and Spanish, and there's a link on the screen if you would like to order that. This is an image of the OTDA 876, which is the request for documents or publications. This is a form that you would use to order AOPs or any other forms or publications you find on the Division of Child Support Services website or the OTDA website. The completed order form should be sent to the email address on the form, which is forms.orders@otda.ny.gov, not to the parentage mailbox. And finally, questions about birth certificates should go to Vital Records. We cannot address those questions, but if you have any questions about the AOP form or process, those should be sent to the parentage mailbox. Again, as Alan indicated earlier, we typically respond the same day or early the following day. And I've also included a link to the Division of Child Support Services website. I encourage you to explore the parentage page for more information and resources.